Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. What a simply massive week for cases. So massive that I had to trim the fat. No time for removal defense adjacent this week. But you know I can't help myself. Heck, I start off with the denats case. And here's what the Ninth Circuit said in its immigration adjacent this week. First, and as widely reported in Nakka et al. v. USCIS, the Ninth held for a couple of reasons that Indian nationals and their derivative children who have been present in the United States for years in lawful H-1B and H-4 non-immigrant status could not sue the U.S. government for the fact that it's taking decades for their employment-based immigrant visa numbers to become ripe and therefore adjust to LPR status. Nor could they sue to keep the children from aging out. What a mess that all is. Really messing up lives too. Again, those kids are going to age out and become visa dreamers. Check out the interview I did years ago on that, Visa Dreamers. Really humanizes the issue. Then, in United States v. Valdivias-Soto, a split Ninth Circuit panel affirmed dismissal of an illegal re-entry charge in criminal court because of constitutionally significant errors in the underlying removal proceedings that led to the non-citizen's deportation in the first place. To the panel, the translator mistranslated the immigration judge's statements that the non-citizen had a right to an attorney at no cost, as the IJ's words were translated that the non-citizen had a right, quote, to hire, end quote, an attorney. The interpreter used the verb contratar, and so, lacking money, the non-citizen didn't try to get an attorney. He didn't think you could get a pro bono one. Pretty wild. So I guess listen to the audio of your client's removal hearing in Spanish if you're trying to make some sort of due process claim. Plus, at the Ninth Circuit, the non-citizen was eligible for a U visa at the time of the removal proceedings, and the IJ should have informed him that he could apply for that, to paraphrase. And those are just the cases we're not doing this week. Here are the 8, that's right, 8, that made it through. Starting off, we're going to do United States v. Munoz, published by the 11th Circuit on August 7th, 2024. Different Munoz, not the Supreme Court's one. This case is about denaturalization and estoppel. That officially makes it a doozy. Mr. Munoz was a lawful permanent resident and applied to naturalize on June 6, 2009. On his application, as one does, he replied no to the absurd question asking whether he had ever committed a crime or offense for which he was not arrested, ever. And then the less absurd question about whether he had ever sold or smuggled controlled substances. He said the same thing, that is no, during his naturalization interview and just before naturalizing at the oath ceremony, and he became a U.S. citizen in September 2009. Nearly 2 years later, however, he was indicted and eventually pled guilty to a drug conspiracy. The second superseding indictment that he eventually pled to alleged that he was possessing and distributing a bunch of cocaine and marijuana, quote, between on or about June 1st, 2008 and on or about May 30th, 2011, end quote. So well before that naturalization, as alleged. I'm telling you, it's these conspiracy convictions that are always at play in denaturalization cases. Mr. Munoz signed the government's statement of facts, which, quote, primarily described drug activities in 2010 or later, but it also stated that an unnamed informant repeatedly picked up marijuana from Mr. Munoz at a drug stash house between 2008 and 2010, end quote. At sentencing, though, Mr. Munoz didn't answer the district judge's question regarding whether he agreed to the statement of facts, and his counsel seems to have been walking a fine line. As such, the federal judge, quote, put aside, end quote, the statement of facts, making clear that Mr. Munoz's plea was not based on it. Instead, the federal judge had Mr. Munoz describe the facts, to which Mr. Munoz described events that began in, quote, late 2008, end quote. Again, that's before he naturalized. He did his time, and 6 years later, likely as a result of former President Trump's famed denaturalization task force, the U.S. government tried to denaturalize Mr. Munoz in federal court. The government has the burden to prove it, and the government alleged, naturally, that Mr. Munoz had illegally procured his naturalization because he had lied about not being involved in any drug or criminal activity when he applied to naturalize, and thereafter before he naturalized. All of that 2008 and 2009 activity would have also barred a good moral character finding for the 5 years pre-2009, argued the government. Lots of reasons, really. And the government's probably totally right if Mr. Munoz was engaging in that drug activity before he naturalized. In big trouble, Mr. Munoz tried to vacate his federal drug offense, based on ineffective assistance of counsel, and to stay his denaturalization proceedings in federal court while he did it. The denaturalization case was stayed, but the same judge who presided over the criminal case the first time now had before him this motion to vacate, and the judge denied it. The 11th Circuit affirmed that separately years ago. So he still has the conviction, and denaturalization proceedings ramped up again. The U.S. government filed motion for judgment on the pleadings, arguing that a trial shouldn't even happen because Mr. Munoz was both collaterally and judicially estopped from denying the admissions that he had made all those years ago about the time period of the drug conspiracy. The district court agreed with the government and denaturalized Mr. Munoz. Mr. Munoz appealed, and the 11th Circuit reversed. True. Denaturalization is required if citizenship was, quote, illegally procured, end quote. But also true, the government has the burden in denaturalization proceedings, and it's a heavy one. And I must stress, as the 11th Circuit does, that this is occurring on the lower court's ruling on the pleadings alone. This case didn't go to trial yet, so the facts of just when Mr. Munoz began his conspiracy aren't really the issue yet. The issue is collateral and judicial estoppel. Back to law school. And I am not qualified to be your professor. Nevertheless, quoting the aptly named Islam v. DHS decision from episode 56, that also shattered my heart at the time, quote, collateral estoppel forecloses relitigation of an issue of fact or law that has been litigated and decided in a prior suit, end quote. It requires 4 conditions be present. 1. The relevant issue must be identical to the issue involved in the prior proceedings. 2. The issue must have been actually litigated in the prior proceeding. 3. The issue's determination must have been critical and a necessary part of the prior proceeding. And 4. The party against whom the earlier decision is asserted must have had a full and fair opportunity to litigate the issue in the prior proceeding. When collateral estoppel is presented before USCIS and then it comes to federal court, the second issue is usually the problem. Whether the issue the non-citizen is trying to collaterally estop USCIS from relitigating was actually litigated in the prior proceeding. And that's what Islam v. DHS was mainly about too. But here, the issue was the third element. To the 11th Circuit, just when Mr. Munoz's conspiracy began was not necessary or critical to convict him. In fact, it's never necessary for criminal convictions, explained the court. Quote, "It is a well-settled rule of criminal practice that the date of an alleged offense, as stated in an indictment, is only material in reference to the bar of limitation, and to show that the offense was committed anterior to the presentment of the indictment." End quote. But flat out, the date of an offense is not an essential element of a conviction. Ever. Very, very interesting, crimmigration nerds. I wonder how else that might affect immigration matters, and in particular, crimmigration and removal proceedings. Say, I don't know, whether a CIMT was actually committed within 5 years of receiving LPR status. DHS's burden, remember. Nor did the district court rely on any specific dates at sentencing, as the U.S. government argued here, and even if it did, that doesn't make the date material to the conviction as collateral estoppel would require. Also, no shade on the district court in holding otherwise, as that judge was relying on an unpublished 11th Circuit decision, which seems to directly support a collateral estoppel finding under these circumstances. But that was unpublished, and no longer. So on to judicial estoppel, which I must admit I've never heard of. That doctrine, quote, prevents the perversion of the judicial process and protects its integrity by prohibiting parties from deliberately changing positions according to the exigencies of the moment, end quote. Fascinating. Whereas here the person at issue was a party to the prior proceedings, estoppel applies if, quote, the party's two positions are clearly inconsistent, the party succeeded in persuading a court to accept its earlier position, and the party must derive an unfair advantage or impose an unfair detriment on the opposing party, if not estopped, end quote. Applied here, yes, Mr. Munoz's positions are inconsistent. He conceded as much. But the second element was not met. The record did not show that the sentencing judge had relied on the date of the offense during sentencing, much less conviction, which would have been immaterial to the court anyway. Importantly, Mr. Munoz simply pled guilty to conduct that occurred within the time frame of the indictment. Nor did Mr. Munoz receive an advantage from ostensibly pleading to facts that began in 2008, the third element. If anything, to me, it kind of hurt him and could have resulted in a longer sentence, right? Because it's a longer period of time of criminal conduct. That's just me. As such, the lower court erred in believing Mr. Munoz is stopped. So it's going back for the government to make its case. Now, don't get me and the 11th Circuit wrong. Mr. Munoz is in for a rough cross-examination if he chooses to testify, and even if he denies committing criminal conduct pre-naturalization and the government doesn't even contradict his testimony, quote, the district court is free to reject his testimony, end quote. So pretty rough. But as stopped, he is not. Quite the case. I hope Mr. Munoz has a heck of a response to the pre-2009 allegations on remand. And that is United States v. Munoz. If you want to get out and stop now, I wouldn't blame you. So long as you laugh at that pun. Next is Joshi v. Garland, published by the 4th Circuit on August 8th, 2024. This is the first of two 4th Circuit decisions, and it's about mental health, persecution, and torture. Mr. Joshi is from India and entered the United States as an F1 student in 2015. He went to Penn State. He's been diagnosed with various mental health illnesses including depression, bipolar disorder, antisocial personality disorder, and schizoaffective disorder. His symptoms include paranoia and delusions. Quote, consistent with those symptoms, Mr. Joshi once convinced himself that he was living in a movie, end quote. He takes antipsychotics. His mental health issues began in India a few years before he came to the United States. He was involuntarily institutionalized for the first time in the U.S. in 2016 after severely harming himself during a, quote, manic episode, end quote. His sibling came to the United States and brought him back to India, where he lived at his father's home in 2016. He was forcibly hospitalized shortly thereafter in India when he stopped taking his medications. That lasted 3 or 4 weeks. Happened again a few months later. Police bound his hands and feet and took him to a facility operated by a traditionalist Hindi sect. He was again given unknown medications and was required to fast and pray and not permitted to see his family. That lasted 5 or 6 weeks. And he only got out because he was able to figure out a way to call his mom, apparently, and his dad arranged his release. Mr. Joshi returned to Penn State in 2017 and was involuntarily hospitalized again in the US when police caught him trying to leap off a balcony to his death. My goodness. He was forcibly committed again and then sent back to India. Another involuntary hospitalization there, and it was pretty rough. Mr. Joshi suspects that his cousin, Abhishek, devised at least some of these hospitalizations in India because he's greedy and thought he could benefit and get some of Mr. Joshi's property as a result. Hospitalized again in April 2019, this time at India's National Institute of Mental Health and Neuroscience, where he was electroshocked once a week for 5 weeks. Electroconvulsive therapy specifically, which is controversial, although performed in limited ways, even in the United States. Permitted to return to Penn State later that year, he was involuntarily committed again a few times in the US. He got related arrests, and then he lost his F1 status in October 2020. Apparently, his mother and friends told him that he could not come back to India, and they didn't want to see him. Mr. Joshi tried to go to Canada, where he also had a visa, but he was denied entry because of COVID-19 and Canada's closure of the border. So he said he was stuck at Penn State. We are. That's actually not true. Go Gators. When his father passed away, he became increasingly, quote, destructive, end quote, getting arrested for disorderly conduct, tampering with a firearm, and even more disorderly conduct in the U.S. He was homeless in 2021. More disorderly conduct, and he's kind of just disintegrating. He was detained and removal proceedings were initiated by ICE in late 2021. And here we are. Asylum was denied, and the Fourth Circuit affirmed. First, the court affirmed the agency's finding that, quote, his institutionalization and modified electroconvulsive therapy did not amount to persecution, end quote. Although the Fourth is sympathetic to an argument that actually any involuntary confinement is persecution. However, quote, a state's legitimate exercises of sovereign authority do not typically constitute persecution, even if its actions restrain liberty or could lead to physical injury, end quote. And LOL, in part quoting Deborah Anker's and Jeffrey Chase's Law of Asylum in the United States, their new 2024 treatise on asylum law. Quoting in a manner that I'm sure the professor and former immigration judge Chase wouldn't wish to be their first precedential quote in the decision, notwithstanding its correctness. Congrats on your treatise, by the way. I'm sure it will help many law students and really anyone who wants to learn about asylum and similar protections. And so to summarize, legitimate criminal incarceration is not persecution, said the court. So too with legitimate required military conscription. And so too with legitimate, keyword legitimate, involuntary mental health confinement. The court's discussion of this includes a big footnote about none other than the parens patriae doctrine, which I made fun of Ira for bringing up during our interview last month. It's Latin, of course, and as the Fourth Circuit explains, quote, states have a responsibility to act as parens patriae, to take care of persons who are legally unable, on account of mental incapacity, to take proper care of themselves and their property, end quote. So that's what that means. In light of all that, it was not unreasonable for the agency to see what India did as reasonable, given Mr. Joshi's history in 2 countries. And the electroconvulsive therapy? Well, it's widely considered a legitimate procedure, said the court, if not controversial. And the facility put him under anesthesia first. It wasn't just cruel, unnecessary pain. Quote, even treatment conditions that are harsher than those prevalent in America do not automatically constitute persecution, end quote. Similar reasons relied on to deny cat protection, too. As to the fact that maybe some of his Indian involuntary psychiatric detentions were done by family members for nefarious means, it wasn't them who then did anything to Mr. Joshi in the facility, and in any event, there wouldn't be a nexus to a protected ground, even if it was the case that they initiated it. Greed and an effort to take Mr. Joshi's property, at most, the record showed, and that is not nexus, said the court. The panel feels for Mr. Joshi, but he did lose his case. Interesting decision, though. And this. In reaching its conclusion, the Fourth Circuit states that, quote, when a state prosecutes and subsequently convicts, sentences, and incarcerates someone pursuant to a generally applicable and fairly administered law, that person is not a victim of persecution, end quote. Citing again Professor Anker and former I.J. Chase. But there are a few qualifiers in there. What happens when laws are not fairly administered in a country, or when laws aren't generally applicable to all portions of a country's society? Grounds for a prosecution as persecution argument, says I. So too with the electrotherapy stuff. Not persecution in part because India, quote, complied with applicable standards of care, end quote. But what if it didn't? Don't forget it. Indeed, quote, all of this, of course, is not to say that involuntary commitment as mental health treatment categorically fails to amount to persecution, end quote. And that is Joshi v. Garland. Next is Garcia Cortes v. Garland, published by the Fourth Circuit on August 7th, 2024. This case is about exceptional and extremely unusual hardship. Judge Rushing dissented. The case uses the word non-citizen in place of the word alien, in conformance with the preferences of most of the Supreme Court, but not two of the ones who have been on it the longest. Ms. Garcia Cortes is from Mexico and has lived in the U.S. since coming here without authorization in the year 2000. She applied for asylum 14 years later in a move that I truly hope was not done simply to obtain work authorization and eventually be placed in removal proceedings. She did not succeed on her affirmative asylum application and was placed in removal proceedings where she applied for non-LPR cancellation of removal under INA Section 240A(b). The immigration judge denied, finding all elements met except the required showing of exceptional and extremely unusual hardship to a U.S. citizen or LPR spouse, parent, or child. Here it was Ms. Garcia Cortes's then 14-year-old daughter. Evidence showed that she suffered emotional issues and would be at increased risk of self-harm if Ms. Garcia Cortes was not permitted to remain in the U.S. The evidence included a therapist's letter, in addition to, of course, testimony and other evidence. The BIA affirmed the denial of cancellation. The Fourth Circuit did not. The court first held that it had jurisdiction to hear the issue because of the Supreme Court's recent Wilkinson's decision. Whether the BIA erred in making a no-hardship finding is reviewable as a mixed question of law and fact, so long as the underlying facts aren't in dispute. By the way, that was already the law in the Fourth Circuit even before Wilkinson and post-Guerrero Lasprilla, so the court took a bit of a judicial victory lap. Bit more nuanced, it always is, Ms. Garcia Cortes was also challenging some of the factual findings made by the immigration judge. The Fourth Circuit held that it could not review those. That's Patel that bars it. But in addition to reviewing the settled facts, there were also settled facts. To determine whether the hardship standard had been met in this case, the Fourth Circuit also held that Wilkinson permits it to review whether the IJ indeed failed to consider all evidence presented. That's not just a reweighing the evidence argument. This is really a statutory procedure argument, explained the court. IJs have to consider all evidence presented in court. So that's a nice little gift for non-citizens on jurisdiction. And like I said, having so found, the Fourth Circuit then remanded. True, it believed the IJ correctly deemed sufficient hardship lacking, based on the facts that the IJ found. As described, the quote, significant emotional and economic hardship, end quote, that the child would suffer if her mother was removed wasn't beyond that normally expected when U.S. citizen children's parents are sent away, and that's the standard that Congress saw fit to place on non-LPR cancellation of removal. The thing is, the Fourth Circuit doesn't believe that the IJ adequately considered that therapist's letter. Particularly important, as in making a decision, IJs must weigh all credible evidence and, quote, may not rely on their own unsubstantiated knowledge, end quote. Importantly, and while the therapist's letter did include an overview of the daughter's mental health, which the IJ considered, it also said that, quote, any separation from her mother will increase suffering and negatively impact her mental health stability, increasing her risks for severe depression, self-injury behaviors, and suicidal ideation, end quote. That was akin to an expert judgment and therefore an expert, quote, predictive judgment, end quote, of what would happen if the mother was removed. A piece of evidence more direct on the ultimate issue in this case than any other piece of evidence. And despite clearly considering this therapist letter, the IJ never addressed the therapist's, quote, expert judgment, end quote, about what removal would do to the daughter. Again, the most important part to the Fourth Circuit, not least of which because that letter also discussed self-harm. Now, I'm not sure, and quite frankly, I wouldn't be surprised if counsel never even tried to get this therapist designated as an expert in immigration court. It doesn't even seem that the therapist testified. Nevertheless, if the IJ wanted to reject this expert opinion, the IJ needed to make a credibility finding, or I guess explain why other evidence negated the expert therapist's opinion. Without doing so, the Fourth Circuit can't adequately review the decision or the BIA's decision affirming it. So the case was sent back. Judge Rushing disagrees and doesn't believe review proper, but that's the dissent. The court held that other evidence was properly considered, like I said, but a remand was still required. What a win for the non-citizen. That's a funny pun because the majority decision is authored by Judge Wynn. You get it. And that means congratulations to Zinzi Kloiba Corbett and J. Marks for petitioner. And remain vigilant about this. As you may recall, Justice Sotomayor remarked in dicta in Wilkinson that a primarily factual mixed question of law and fact might entail, quote, a more deferential standard of review, end quote. The panel found no need to really explain what types of mixed questions require that more deferential review because no matter the review applied in this case, the panel believed a remand required. Quote, future courts will need to determine whether a mixed question is primarily factual or primarily legal and to select a correspondingly deferential standard of review, end quote. So watch out for that in the Fourth Circuit and really everywhere. But I guess it's not all hardship questions, right? Not all require a deferential review. Because then there wouldn't be much determination required of future panels at all. It would be pretty easy, says I. And that is Garcia Cortes v. Garland. Moving on to Bustos-Millan v. Garland, published by the Seventh Circuit on August 6, 2024. This case is about ineffective assistance of counsel. And it's a nightmare, of course. This asylum-seeking family is from Mexico and they hired an attorney. Quote, that attorney, despite having nearly 15 months to prepare, waited until 8 days before the hearing to request a continuance. The immigration judge denied the motion in open court and began the hearing, prompting the attorney to profess that she could not proceed due to a lack of preparation, end quote. Specifically, the attorney blamed the 2018-2019 government shutdown, but didn't expand, it appears. The IJ even offered her the opportunity to file late-filed documents the day of the merits hearing, but the attorney could not do so. Asylum was denied. The petitioners here, represented by the same attorney, filed an appeal with the BIA. The BIA dismissed the appeal. New counsel filed a petition for review. But to be fair, work was done on the cases of some of the family members even after the BIA's order. 2 of the minor petitioners got special immigrant juvenile status before USCIS. And then that same IJ, I guess, or the BIA, a bit unclear, reopened and terminated their cases. So 2 of the family members are not before the Seventh Circuit in this petition for review, the circuit explained. That left 4 non-citizens before the court to challenge the denial of the continuance, and they did not succeed. Continuance motions are subject to the good cause standard, and they're reviewed by the circuit court for abuse of discretion. The Seventh Circuit did not see that standard met here. Quote, when petitioners or counsel fail to adequately prepare for a hearing, an IJ does not abuse his discretion by denying a motion to continue, end quote. Petitioners' counsel argued that the IJ should have followed matter of Hashmi from 2009. But the Seventh Circuit was unmoved. To recap, for those of you who desire to continue, quote, in matter of Hashmi, the non-citizen asked the IJ to continue his removal proceedings so DHS could adjudicate his status adjustment application based on his marriage to a United States citizen. The Hashmi court outlined several factors IJ should consider when evaluating motions to continue where an immigrant is involved in other proceedings. Contrary to petitioner's argument, those factors do not apply here because there is no record evidence suggesting that the petitioners were involved in any other proceedings when their hearing took place, end quote. That is, there was no collateral USCIS thing going on. In any event, the 2018 decision from Attorney General Sessions, matter of LABR, seemed more appropriate to govern the motion, explained the court. Give it a read, but I will note for everyone that it is fairly easy to distinguish one's own case from the 3 continuance requests at issue in LABR, rejected by Attorney General Sessions in that case, as all of them were quite extreme. Just saying. Give it a read and decide for yourself. Nor did the IJ violate the petitioner's due process rights. The IJ provided counsel the opportunity to argue for a continuance even the day of, but found the arguments unpersuasive. Plus, counsel had lots of time to prepare for the hearing. The non-citizens also asserted ineffective assistance of counsel before the 7th Circuit, but I have a feeling why that's not going to win. To begin, yes, the 7th Circuit states that, quote, reasonable jurists might find it met on the facts of this case, end quote, choosing its words carefully, as I have tried to do throughout as well. But as I suspected, the claim is unexhausted that is ineffective assistance, as it was never made before the BIA, possibly because the same attorney who represented the family at the IJ level then represented them at the BIA level. Quote, we recognize that this rule creates something of a catch-22 for petitioners, who were represented by the same counsel in immigration court and before the BIA, end quote. The 7th Circuit suggests that the appropriate move by new counsel would have been an ineffective assistance of counsel motion to reopen with the BIA, and then an appeal of that denial if required. Tough time limitations and substantive requirements, explain the court, but the option does exist. Quote, given the gravity of the consequences petitioners faced because their counsel was unprepared, this might be a case where the government should consider agreeing to reopen the proceedings in the name of justice, end quote. But the 7th Circuit believed that it could not do so. And so, it dismissed the petition for review. And that is Bustos-Millan v. Garland. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Attention lawyers looking to dive into immigration law. Are you ready to master the art of marriage-based immigration? Introducing the Ultimate Marriage Green Card course, a comprehensive resource by John Khosravi, founder of the Immigration Lawyer's Toolbox, to kickstart your journey in family-based immigration. His course offers 18 hours of engaging video content and includes monthly office hours for your questions. You'll analyze and learn, through the statutes, regulations, case law, and real-life practice, essential topics like 212 inadmissibility, 245 adjustment, consular processing, and the affidavit of support requirements. The course will also cover practical office procedures, consultations, and sales techniques. Plus, you'll receive helpful samples and templates to streamline your practice. As a limited-time special bonus, the Immigration Lawyer's Toolbox is adding the recordings of an all-day O1 seminar with the best O1 lawyers in Los Angeles. Go to immigrationlawyerstoolbox.com and click on the course link
or email John at info@immigrationlawyerstoolbox.com to sign up. Reference me, Kevin, or the Immigration Review Podcast and get an additional 10% off. Or of course, click on the link in the show notes.
Welcome back, where I will shepherd you through 3 First Circuit decisions that are very long and all pretty bad for non-citizens, before we conclude with a nice one from the 6th Circuit. The first case after our break is La Fortune v. Garland, published by the First Circuit on August 5th, 2024. This case is about particularly serious crimes. Mr. La Fortune is from Haiti and was brought to the United States at 12 years old in 2008. He had a tourist visa, and he was not sent back to Haiti by his family when his time ran out. Then in 2019, as a young man, he pled guilty in federal court to conspiracy to commit bank fraud in violation of 18 USC section 1349, and aggravated identity theft in violation of 18 USC section 1028A(1). He got 7 and 24 months incarceration, respectively, and was ordered to pay victim restitution. He was definitely removable as a B2 overstay, but DHS also alleged that at least one of the convictions was an aggravated felony, as defined at INA section 11843MI, a fraud or deceit crime involving $10,000 or more in loss to the victims. Mr. La Fortune was given an opportunity to get an attorney, but when he didn't have one by the second hearing, he was required to admit or not admit, and concede or not concede, the allegations in the notice to appear. And he admitted and conceded. Removable, Mr. La Fortune asked for asylum and related relief and protection. Unbeknownst to him, I imagine, having just conceded that he had an aggravated felony conviction, he was now ineligible for asylum. He applied, and still without an attorney at the 3rd hearing, but asking for more time to get one, the IJ held the hearing. Mr. La Fortune testified, and the IJ denied everything. Mr. La Fortune appealed the decision to the BIA by himself. The BIA remanded, particularly as Mr. La Fortune had submitted a letter to the IJ from the Boston Immigrant Justice Accompaniment Network, BJAN, asking for more time to complete its efforts to get Mr. La Fortune an attorney. Still unrepresented, though, the IJ continued proceedings again on remand. Although these were relatively short continuances, seems like he was probably detained. And despite another BJAN letter, the IJ then went forward at the 2nd hearing and denied everything again. This time the BIA affirmed. An attorney finally came in on appeal to the BIA, by the way. The First Circuit affirmed. And now, we shall learn the substance of this dispute. It was mostly about particularly serious crimes, as I mentioned at the top. An aggravated felony is a per se particularly serious crime for asylum purposes, but not for withholding, with only that 24 months of incarceration. Nevertheless, an aggravated felony, or any crime really, can be a particularly serious crime for withholding purposes, even if it doesn't have the incarceration, applying the matter of NAM analysis. Mr. La Fortune argued that the IJ never actually said which conviction was the particularly serious crime, which I can only imagine would have required a remand if true, but the BIA said that the IJ said that it was the bank fraud conspiracy conviction, and the First Circuit similarly read the record. The NTA actually only relied on the bank fraud conspiracy. To the extent the IJ's words were less than clear, the IJ's analysis was not. So this is about bank fraud conspiracy. Okay, Mr. La Fortune argued. Matter of NAM still requires, as a threshold showing, a finding that, quote, the elements of the offense potentially bring the crime into the category of offenses that constitute particularly serious crimes, end quote. Only if they do can an IJ jump into the facts and circumstances and other factors discussed in matter of NAM and matter of Frantescu. This is precisely how I understand matter of AM, and how the Fourth Circuit recently explained it in a Norby Garland episode 203. Also a fraud financial type conviction case, by the way. Mr. La Fortune's attorneys, in fact, made all those arguments. Mr. La Fortune, quote, contends that the IJ did not, for example, identify the nature of Mr. La Fortune's crime, i.e., crimes against persons or crime against property, or explain how the element of defrauding a financial institution makes bank fraud fall within the ambit of a particularly serious crime, end quote. And to the First Circuit, the IJ clearly did not follow quote, the rigid two-step analysis that Mr. Lafortune contends NAM requires, end quote. That means that Mr. Lafortune, quote, is right, that if matter of NAM did require the agency to follow the strict two-step framework for analysis, the agency here would have erred, end quote. Okay. But agreeing with Oyle's arguments, the First Circuit then held that matter of NAM does not, quote, require the agency to undertake an explicit elements-only analysis prior to delving into a discussion of the case-specific factual circumstances of the case, end quote. If you heard something weird, that was my mind melting and my heart breaking. To get there, the First Circuit first sees that all that step-by-step language in matter of NAM is kind of dicta-like. In any event, and although, quote, NAM does say that, quote, from NAM, once the elements of the offense are examined and found to potentially bring the offense within the ambit of a particularly serious crime, all reliable information may be considered, end quote, from NAM, it does not say at any point in its analysis that the agency must explicitly state that the elements of the offense have been examined, end quote. I guess. Nor does matter of NAM say at any point that such an examination must explicitly, and not implicitly, precede the analysis of, quote, all reliable information, end quote. Simply devastating. A two-step framework, to be sure, reasoned the First Circuit, but not in any particular order, I guess. Doesn't quite make sense to me then to call something a two-step framework, but I am not a judge. The First Circuit didn't believe that this outright conflicted with the other circuit precedent that Mr. Lafortune cited, but I don't think that Mr. Lafortune cited Honor v. Garland, given the recency of that decision, which does conflict, says I. Also, the First Circuit believes this comports with a Ninth Circuit decision, Bear v. Barr, episode 21. Nor did the First Circuit believe that the BIA weighed the factors wrong. Those factors are, quote, the nature of the conviction, the circumstances and underlying facts of the conviction, the type of sentence imposed, and most importantly, whether the type and circumstances of the crime indicate that the non-citizen will be a danger to the community, end quote. And at this stage, the IJ did deem the nature of the conviction showed that it was particularly serious, even though it wasn't a crime against persons. Crimes against property or mere financial crimes can be particularly serious, implicitly held the First Circuit, although technically it seems that the analysis was affirmed on a failure to exhaust ground. To the court, the IJ did consider mitigating factors and rejected them, and the IJ considered that the crime indicated that Mr. Lafortune was dangerous. So particularly serious crime finding affirmed. Leaving only Convention Against Torture deferral. And Haiti is a pretty bad place right now. Remember, pro se before the IJ. The IJ said that all evidence was considered, even if not mentioned. Plus, the IJ said that the harm to Mr. Lafortune's father in the past and continued death threats to the father were considered. But to the IJ and the First Circuit, and the BIA, I guess, the dispositive issue is that Mr. Lafortune didn't provide specific examples of harm other than a threat to burn down his father's home, and nothing towards Mr. Lafortune himself. And the father still lives in Haiti, unharmed, though maybe unsafe. So too with some other evidence. I told you these were long ones from the First Circuit. As to the fact that the Department of State essentially describes Haiti as a failed state, at the moment, it still didn't show a, quote, particularized risk of future harm, end quote, to Mr. Lafortune specifically, and so country condition evidence will rarely if ever make that showing on its own. Accordingly, and even though he was pro se, the IJ didn't err in not taking administrative notice of the country condition report because I guess it wouldn't have moved the needle on cat protection anyway. Nor did the IJ err in refusing to reopen the record on remand, given the BIA's language in remanding proceedings, and particularly, I guess, given the fact that Mr. Lafortune never did get an attorney, which really was the point of the remand. But also, as attorneys have emailed me, wondering, after reading the case, what is the point of the BIA remanding to give a pro se non-citizen the opportunity to get an attorney, if that same order isn't also read to permit new evidence be submitted in argument on remand? What then is the point of a new attorney for which proceedings are being remanded for? A curious quandary, to say the least. Anyway, the BIA's related affirmance of that was good enough, explained the First Circuit.
Finally, the First Circuit did not believe that the record compelled the finding that Haitian police would consent or acquiesce to the harm against Mr. Lafortune and his family, given, for example, the fact that his father had made police reports in the past at least 4 times, and police indicated that they would investigate. And so Mr. Lafortune did not succeed. Harsh for him and devastating for the particularly serious crime step-by-step analysis that I had hoped would not become a circuit split based on a reasonable reading of matter of NAM, but here we are. Get your gongs ready. And that is Lafortune v. Garland. Next is De Oliveira Rodriguez v. Garland, published by the First Circuit on August 8, 2024. This case is about credibility. Miss De Oliveira Rodriguez and her daughter are from Brazil. They came to the United States and applied for asylum. In large part, the credibility issue began with the credible fear interview, which they passed and got them the chance to apply for asylum in removal proceedings in the first place. The asylum officer asked Miss De Oliveira Rodriguez quite a few questions and then summarized her testimony relevantly as follows, quote, "You testified that you were threatened by drug dealers in Brazil because you informed the police on them, and you are a single mother. You fear that if you return to Brazil, the gang members will kill you because of these reasons." End quote. Ms. De Oliveira Rodriguez indicated that this was correct, and never mentioned an individual named JC. She also didn't have an attorney, it seems. The sworn statement that she later filed in immigration court, once she got an attorney, mentioned a man named JC, a known drug dealer, and mentioned him heavily. And as an attorney, well, I can tell you, we are often better at digging deep into a client's story over a period of sometimes 20 hours or more than are asylum officers. Just saying. Apparently, JC believed that Miss De Oliveira Rodriguez, his neighbor, called the police on him for having a large party. She didn't, but that led to terrible threats and a series of events that Miss De Oliveira Rodriguez's sworn statement attested, all resulted in her flight to the United States. She testified to even more bad stuff that JC did on direct examination during her removal hearing. She also mentioned that she had experienced discrimination in Brazil because she was of indigenous descent. Lots of discrepancies and omissions were identified and asked about on cross-examination and by the immigration judge, though, including about the fact that there was no mention of JC during the credible fear interview, and including the fact that she was actually married and her husband came to the U.S. with some of her other children at around the same time that Miss De Oliveira Rodriguez did. Remember, she said she was a single mother in her credible fear interview and that was part of the reason for the harm? The immigration judge found her not credible for a whole bunch of reasons, nearly 2 pages of bulleted reasons in this First Circuit decision. It's a lot. The BIA affirmed, as did the First Circuit. Adverse credibility findings can and almost always will take an asylum and withholding of removal claim because without credible testimony, a non-citizen can't really meet their burden of proof. At the circuit level, though, quote, adverse credibility findings will only be upheld if they are supported by the record and the agency has given reasoned consideration to the evidence and has provided cogent explanation for its finding, end quote. That's a good standard to put in your briefs. In this case, 9 inconsistencies were found by the IJ and upheld by the BIA, inconsistencies that the First Circuit believes are, quote, plain as day, end quote. So that's not a great way to start off the analysis for the non-citizen. And it seems that Ms. De Oliveira Rodriguez agrees, at least in part. She just argued that she gave adequate explanations, and that some of the omissions don't mean that the rest isn't true. The First Circuit disagreed. All the tribunals had a lot of trouble with Ms. De Oliveira Rodriguez saying that she was a single mother who wasn't in contact with her ex-husband when she most definitely was not a single mother and was very much in contact with him, and he played a bit of a role in the whole JC story. As to the JC story, Ms. De Oliveira Rodriguez did mention a lot of the substance, although again, didn't say JC's name to the asylum officer. But in any event, Ms. De Oliveira Rodriguez apparently told the asylum officer that they targeted her because she knew they dealt drugs, whereas her written statement said she didn't know her neighbor was a well-known drug dealer. Not entirely inconsistent, but pretty close, and the First Circuit wasn't going to overturn the fact finder on that. Turning to the omissions, well, there were at least 5 things said at Ms. de Oliveira Rodriguez's individual hearing that were not in any of the prior documents or interviews. And it's true that the credible fear interview notes are not verbatim transcripts, but they're rather more akin to summaries, and that the agency errs where it, quote, fails to treat the notes as the sketch that they represent themselves to be, end quote. Also a good quote to remember. But the omissions here weren't just from the credible fear interview. Some were from the I-589 and even written affidavit of harm. And even if not such large omissions, the Real ID Act allows for an adverse credibility finding to be based on lots of stuff, even if it doesn't go to the heart of the claim. Adverse credibility findings must be based on the record in totality, and here, the omissions weren't the only issues anyway, explained the court. Nor did Ms. de Oliveira Rodriguez really submit specific corroborating evidence. Declining to consider some legal issues raised by ACLU Massachusetts on amicus, the First Circuit affirmed the removal order against Ms. de Oliveira Rodriguez and her derivative daughter. And that is de Oliveira Rodriguez v. Garland. Concluding the First Circuit's big week, we have Gonzalez-Arevalo v. Garland, published by the First on August 7th, 2024. This case is about asylum and nexus. Mr. Gonzalez-Arevalo is 38 years old and from Guatemala. He entered the United States without authorization in 2003, left in 2010, and returned without authorization in 2012. 212A9C barred there. But he wanted asylum anyway, and he was placed in removal proceedings after passing his credible fear interview. He explained that relatives of the man who murdered his father and uncle believed that he was responsible for the man's incarceration, the murderer, and so asserted that his fear was based on his membership in a related particular social group. Pretty detailed, actually. His father was killed by a local gang. The gang chased Mr. Gonzalez-Arevalo and set fire to his car. Looks like this happened when he was very young. And they murdered his uncle too. The leader was imprisoned for it. An unknown gang killed 2 of his cousins and a family friend as well. The particular social group? Guatemalan males who and whose family have suffered past persecution by means of murder of the father of the family by gangs. There were also attacks in 2010. Looks like somebody likely put a bomb in his car and exploded the car, and then he was chased by men with guns at a wedding. He didn't know who though. Either attack, really. The IJ found Mr. Gonzalez-Arevalo credible, but believed if anything it was simply retribution or perceived retribution for putting the gang leader away, not on account of any viable particular social group. The BIA affirmed. Other reasons too, but it's nexus that's relevant here. The First Circuit agreed. It even considered a family-based particular social group too, but rejected it all. To be a viable nexus for asylum at least, a protected ground must be one central reason for the harm suffered or feared. There can be other reasons as well. The protected ground, quote, need not be the sole factor driving the alleged persecution, end quote. But it must be the, or I guess a, quote, root of the persecution, end quote, so that it itself brings about the persecutory conduct. Whether the actual particular social group alleged or any family membership, the court didn't see the nexus. Events stemming from personal disputes, explained the First Circuit, quote, are generally not enough to show the required nexus, end quote, unless, of course, that results in a greater animus towards the family that leads to other risks. That's just me here, and some circuits recently. An attack by a gang because the gang thinks that you're responsible for the leader's incarceration is more of a personal dispute, said the court. And even Mr. Gonzalez-Arevalo agreed with the IJ that the attacks were, quote, reprisals, end quote, after all. There were later attacks, yes, and even killings of family members, but Mr. Gonzalez-Arevalo didn't know who did it. Severely undermines a claim to nexus. In a first for the podcast, Mr. Gonzalez-Arevalo attacked his own testimony, arguing that it itself, his testimony, was, quote, speculative, end quote, and argued that the agency therefore erred in relying on it to find nexus unestablished. I think my head might explode with that one. What with it being an inversion of the usual arguments. The First Circuit rejected it. The agency can rely on credible asylum seeker testimony. At base, not enough evidence of nexus to family or another protected ground, plus some less than helpful testimony, is what tanked the case. Prepare your clients well, and laser-focus testimony on your proposed central reason. And that is Gonzalez-Arevalo v. Garland. Welcome to the end, where we have Tista Ruiz de Ajulipe v. Garland, published by the Sixth Circuit on August 9th, 2024. It's a long case about domestic violence type claims, and I'm going to have to say that difficult name many times. Enjoy the ride. Miss Tista Ruiz de Ajulipe is from a remote village in Guatemala. She came to the United States and sought asylum on behalf of herself, her 3 children, and even her grandson, which I'm pretty sure you can't do. I'm sure they had their own related affirmative asylum applications. Here's the story. She's from a small village in a mountainous region in Guatemala with no police, nothing, quote, to protect women from violence, end quote. Her eldest daughter entered a relationship with an adult man named Marvin when the daughter was only 15. Marvin abused the daughter and even tried to forcefully abort her baby when he learned that she was pregnant from him. It's his baby too. The baby was born. He continued horrible physical violence against the daughter, and psychological as well. Marvin was also dependent on drugs and alcohol and was associated with gangs. Really, like, the worst guy. When the daughter eventually had enough and kicked him out, Marvin threatened to kill the whole family, making that threat while sharpening a machete in front of them. He left but returned later and made similar threats. Miss Tista Ruiz de Ajulipe took the family on a day-long trek to make a police report. Took a whole day to get there, but instead of arresting Marvin, the police required that the daughter undergo a psychological exam before they would do anything. That just wasn't in the cards for a variety of reasons, and quite frankly, it's offensive. Knowing this, the risks of taking another day-long trek to get the exam and leave the family exposed, and knowing that Guatemalan police, quote, ignore or fail to protect victims of domestic violence, end quote, Miss Tista Ruiz de Ajulipe somehow brought the whole family to the United States. The immigration judge denied, mainly because of Jeff Sessions' matter of AB decision, which tried to destroy domestic violence type asylum claims forever. To summarize 8 years of precedent. Indeed, the IJ appears to have excluded some testimony, believing it not relevant in light of matter of AB. The IJ found Miss Tista Ruiz de Ajulipe credible and even held that her family had suffered harm that amounted to persecution. But the IJ believed that because of matter of AB, U.S. asylum law didn't protect people like Miss Tista Ruiz de Ajulipe and her family. And heck, the immigration judge was probably right. That is the world that Attorney General Sessions and the Trump administration desired by precedential decision the first time around. But before the BIA ruled on appeal in this case, Attorney General Garland vacated both of the A-by in matter of AB the third. Now, matter of ACRG and its kind of favorable view of domestic violence type claims is back again for asylum. It's still a very fact-specific analysis under matter of ARCG, particularly the social distinction prong, explains the Sixth Circuit, quoting matter of ARCG itself. Nevertheless, the BIA affirmed the removal order, believing that Sixth Circuit law barred recognition of the group, quote, victims of domestic violence, end quote. The Sixth Circuit remanded by split decision. To be a particular social group, the group must be immutable, particular, and socially distinct, and in the Sixth Circuit, can't be circular. That means that, quote, the group must share a narrowing characteristic other than its members' risk of being persecuted, end quote. That's what it means to not be circular. But in the Sixth Circuit, as well as the various circuits that it cites, IJs and the BIA can't just rely on a non-citizen or her attorney's potentially circular definition of the group. IJs and the BIA, quote, have an independent role to assess the plausibility of the application on the record as a whole, end quote. Restated, the agency can't just deny, quote, merely by the language used, rather than determining what underlying characteristics account for the fear and vulnerability, end quote. So that's a big deal. citing to the 7th Circuit and DC Circuit as well for support. And while the 6th Circuit doesn't say it after those quotes, I don't see how such a rule, including those of those two other circuits, doesn't completely contradict and so make bad law in those circuits, matter of WYC and HOB from the BIA in 2018. The IJ double-erred here, explained the 6th Circuit. Not only did the IJ not look to see whether the facts elicited might show that the persecution was on account of a viable particular social group, but the IJ prevented Ms. Tista Ruiz de Ajulip's counsel from eliciting such facts, believing that matter of AB broadly and completely was dispositive. The BIA should have remanded for further fact-finding after matter of AB the 3rd held the 6th Circuit. ARCG again requires a fact-intensive analysis. To be fair, explained the 6th Circuit, the IJ might not have been entirely wrong at the time, but the IJ was wrong by the time the BIA ruled, for sure. Both the IJ and the BIA again, though, definitely erred in failing to perform their, quote, independent role, end quote, to make a particular social group determination based on the record as a whole and not simply by the words used to define the group. At least when it comes to circularity. This obligation is actually one found under, quote, international law to extend refuge to those who qualify for such relief, end quote. If the BIA, quote, wishes to deny an asylum claim on the basis of circularity, end quote, then it's got to look at the record as a whole and conduct the proper analysis, which looks like requires seeing if there are non-circular particular social groups available. In this case, the facts such as the remoteness of where the family lived, the lack of authorities to protect women, and no apparent escape from their abuser might have shown persecution on account of a viable particular social group. And again, counsel was somewhat prevented from developing the record further. Also said the 6th Circuit, check out Juan Antonio v. Barr, episode 4. Pretty close particular social group recognized. And that was Barr! Or the wonderful Tercios Flores decision from episode 158. That's all from the 6th Circuit, without, of course, the episode citations. The court also found it, quote, troubling, end quote, that the IJ asked Ms. Tista Ruiz de Ajulip the clearly legal question of whether she thought her particular social group was distinct in her society, rather than asking her attorney. And even though Ms. Tista Ruiz de Ajulip didn't comprehend the question. The court also held that the IJ failed to analyze another related proffered group. There's a lot in this case. This is a very long decision that probably cites every non-citizen-friendly 6th Circuit particular social group decision in existence, so mark it for your research. And oh yes indeed, I spoke too soon. The dissent kind of said exactly what I did about matter of WYC and HOB before. As a result, the majority addressed that issue at the end of its decision. According to the majority, apparently, that BIA decision, quote, itself even emphasizes that the IJ should seek clarification if an applicant is not clear as to the exact delineation of the proposed particular social group, end quote. With that quote and others, the majority tries to bring WYC within its rationale and held that its decision here is not contradictory of WYC. But I don't know. I'd say that an IJ who relies on WYC and HOB to find no viable particular social groups, where the evidence indicates that one might exist, and without then conducting an additional analysis, does so at his or her own peril in the 6th Circuit. The majority also believe that the IJ improperly disregarded evidence about the Guatemalan government's ability or willingness to protect. Heck, instead of investigating, the police questioned the daughter's psychological state, remember? And that was a whole day's trek away anyway. Based on that and other quote evidence in the record, Ms. Tista Ruiz de Ajulip could not reasonably expect the assistance of the government in controlling Marvin's actions, end quote. Strong words. Withholding of removal remanded to. An absolute novel of a decision and an important remand in the 6th Circuit. So congratulations, Stephen C. Knight from Tennessee, for petitioner. Judge Larson authored an equally forceful and lengthy dissent, but it is 8 p.m. Friday night. KG, out. And that is Tista Ruiz de Ajulip v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.